Hello friends, this is Dr. Harsha Suryamshi, Associate Professor from Sri Shivaji Law College, Parvani, Maharashtra. In the video, we shall discuss provisions for industrial disputes and authorities, that is, the Industrial Tribunal and National Tribunal. According to Section 7A, the appropriate government shall constitute industrial tribunal. The tribunals have many trappings of a court, but they do not have the same status as courts. The tribunals are not required to follow the strict technicalities of law while adjudication of industrial disputes, and therefore the industrial tribunals or the tribunals in general are fast in disposal of cases. The industrial disputes can be settled by the industrial tribunal whenever the appropriate government thinks that there is need to constitute industrial tribunal, it shall constitute. The presiding officer of industrial tribunal shall be decided by the appropriate government. The appropriate government shall notify in the official gazette about appointment and names of persons who shall constitute the tribunal. Who can become member or presiding officer of industrial tribunal? The idea says that any person who is or who has been judge of high court can become presiding officer of tribunal, or if any person has been a district judge or additional district judge for at least 3 years is also qualified to become presiding officer of the tribunal. Now, what are the duties of presiding officer of industrial tribunal? The industrial tribunal can adjudicate upon matters which are stated in the second or third schedule of Part 1 of the Industrial Disputes Act. The industrial tribunal can settle the dispute regarding wage period and mode of payment of wages. The industrial tribunal can also adjudicate upon compensatory holidays or allowances and other allowances. The industrial tribunal can adjudicate or decide disputes relating to hours of work and rest intervals for the workmen. If there are any disputes which have subject matter of leave with wages or holidays, the industrial tribunal can decide such disputes. Whenever there is a question of bonus or profit sharing or provident fund or gratuity, the presiding officer of industrial tribunal can decide the matter. The industrial tribunal can also settle the dispute relating to retrenchment of workmen and closure of establishment. As regard national tribunals, Section 7B states that the national tribunal shall be formed or constituted by the central government. The central government only can constitute the national tribunal by notifying in the official gazette. The central government shall also notify name of the person who shall constitute the national tribunal. The jurisdiction of national tribunal is also decided by the central government. While deciding the jurisdiction of national tribunal, if the central government opines that the industrial dispute involves question of national importance, it shall constitute the national tribunal and refer the dispute to national tribunal. If the national government or the central government is of the opinion that industrial dispute is of such a nature that industrial establishments or industries situated in more than one state are likely to be interested or affected by the dispute, then the central government can constitute national tribunal. That means the national tribunal can be constituted or the dispute can be referred to the national tribunal only if the industrial dispute is of national importance or the industrial dispute is going to affect industry of two or more than states, more than two states in India. The National Tribunal shall comprise one person who shall be appointed by the central government. Only a person who is presently judge of a high court or a person who has been judge of high court is qualified to become presiding officer of the National Tribunal. The central government can also appoint two persons as assessors. These two persons can advise the National Tribunal in the proceedings before the tribunal. Thank you, friends. Thank you very much.